Before we get started, please go over to Amazon.com and grab a copy of my book, Education and Justice. If you have an African-American son in public school, you need this book because I teach you the many ways that public schools mistreat African-American boys and what you can do to help your son. So go over there and get your copy immediately. All right, folks, I hope you're doing well. So let's get into this video. We got new developments in the Texas redistricting case. So a couple of days ago, we got some really great news that 2 judges out of a 3-judge panel said no to Greg Abbott and to Trump regarding the new map that they had drawn, which would give Texas an additional 5 seats, which would help Trump basically rig the 2026 midterm. So I made a video and went through that and walked through that, their opinion. All right. They issued a preliminary injunction. They stopped the state of Texas from using the new map. They got to stick with the 2021 map. And so we celebrated. Now, I did notice that there was no dissent. The one judge who did not rule with the 2 majority, that judge's dissent was not included in the order from yesterday. Well, now we know why. There's a whole lot of back and forth going on between that judge, the dissenting judge, and the 2 judges who gave Texas and President Trump a no. And it is the dissenting opinion that this dissenting judge wrote is crazy. I've been reading these cases, constitutional law cases, civil rights cases. I've been reading them as far back as 2000. I went to law school. I think I started law school in 2000. So I've read maybe thousands of these cases. I've never read an opinion, a dissenting opinion like this. It is off the rails. I'm reading it. As I was reading it with my jaw dropped, my mouth wide open, like, what? This is bananas. This judge just lets it all come out, everything he's feeling. And, he was just not very happy, and that's an understatement, with what the 2 judges did, and his ire, his anger, his angst, his frustrations are all targeted toward the Trump-appointed judge who wrote the majority opinion. He goes in on that Trump-appointed judge. And this particular judge, he himself is a Reagan appointee. So he's a Republican too. And there is, by the way, the judge who wrote the majority opinion, Judge Jeffrey Brown. Oh boy, he is, again, a Trump appointee, and folks here in Texas, the conservative folks here, the MAGA people here are going crazy. They feel like he's a traitor, that he betrayed them with this ruling. They are going off on him. And all of that is expressed in this judge's dissenting opinion. Now, you may ask, what impact could the dissenting opinion have on the case? Well, it could have a great impact on the case. Because often when we're reading these cases, we always read the dissenting opinion. Because what's the dissenting opinion now could become the majority approach in the future. And in this case, it feels like the judge is trying to send a message to SCOTUS, right? He is just going off. He's saying all sorts of things about Judge Jeffrey Brown and just saying, it is really, really, really crazy. It's the craziest I've seen. It's not the worst that I've seen. The worst case that I've ever read in my life is the Dred Scott case. All right, that was an awful, the worst case I think ever written by the United States Supreme Court. But this is the craziest. And I say that respectfully, but it is crazy. I'm sure that when law students read this is going to be very, very, very entertaining. But for right now, he is trying to absolutely send a strong message to SCOTUS and to everyone else to come out against this judge, to come out against Judge Jeffrey Brown. He is essentially saying what this judge did was completely improper, totally. We're going to read some of it because I can't adequately describe what this dissenting opinion does. We're just going to read through it. And it's not a whole lot of legal stuff in the beginning. It's just him venting and trying to expose his fellow judge who had the gall, the audacity to go against MAGA, to go against Trump, to go against Greg Abbott. And so that's what you feel as you read this. So let's go to another screen so that we can read through some of this opinion. Again, crazy, crazy, crazy. All right, is it large enough? Let me make it a little larger so that, if you're on your phone or something, which most of you are, you can still read along. All right, so this is a little better. Jerry E. Smith, pardon me. So he is the dissenting judge. There were 3 judges, 2 voted against the new map, and this judge would have approved the map. So he's dissenting. Notice what he opens up his dissenting opinion with. He says, quote, "Fasten your seatbelts. It's going to be a bumpy night," close quote. So he's coming out of the gate like a bull in a china shop. I am not exaggerating. I've never read most of these opinions. They try to stay, respectful and so on. There's some tense moments sometimes, like when we have read Justice Jackson's opinion, dissenting opinion, and then read the majority opinion, especially the one with Amy Coney Barrett. And then Justice Jackson had that kind of situation with Clarence Thomas in the affirmative action case. So sometimes it can get, and as you're reading the case, it's kind of entertaining and so on and so on to hear the judges going back and forth like that in their opinions. They don't get in each other's faces, not at least publicly, but they let how they feel come out in their writing. But in this case, let's read. "Fasten your seatbelts. It's going to be a bumpy night. I dissent from the entirety of Judge Brown's opinion granting a preliminary injunction." So he first makes a preliminary statement. He says, "I append this preliminary statement to dispel any suspicion that I'm responsible for any delay in issuing the preliminary injunction or that I am or saw slow walking the ruling. I also need to highlight the pernicious judicial misbehavior of U.S. District Judge Jeffrey Vincent Brown," and says his whole name, calls the judge's ruling pernicious. Misbehavior. He is attacking the other judge. He is teed. He's angry. And he's letting it come out. You may say, well, why are you so up about this? Well, first of all, as a lawyer, as an attorney who's read so many of these, this is one that I've never seen before. and I've read thousands of these. And this is my space, so I'm getting a kick out of it. I strongly disagree with the dissent. I agree with Judge Jeffrey Brown, who wrote the majority opinion. But it is, interesting to see these two judges sparring like this publicly. And that's what this is. This is a spar. All right. They didn't keep it behind their chambers, in their chambers locked away so the public, no, this judge brought it out. He brought it out. I think he's wrong in what he says, but he brought it out. He says, in my 37 years on the federal bench, this is the most outrageous conduct by a judge that I've ever encountered in a case in which I've been involved. In summary, Judge Brown has issued a 160-page opinion without giving me any reasonable opportunity to respond. I will set forth the details. The readers can judge for themselves. The three-judge district court held a 9-day evidentiary hearing / trial on the motion for preliminary injunction. The hearing was concluded Friday, October 10th. The judges immediately retired to confer. Judges Brown and Guadarrama, I'm probably misspelling it or misstating it, voted to grant the preliminary injunction. I voted to deny. It was understood that the majority judges would begin putting together an opinion. This is their process. During the next 26 days, there was silence. Nary a word from either judge. On Wednesday, November 5th, Judge Brown sent me a 13-page outline of the expected majority opinion, quote, so that you and your chambers might be able to begin preparing your dissenting opinion, close quote. Nothing else for a week. On Wednesday, November 12th, Judge Brown sent a message stating, quote, we currently anticipate issuing an injunction on Saturday, November 15th. We will endeavor to get you a draft before we issue it. Sadly, we do not believe we can wait for a dissenting opinion before we rule. The fuse is simply too short in light of Purcell. We will, however, note on the opinion that you are dissenting. We are not trying to cut you out. We just don't have the time. Ideally, of course, we would have liked to have seen your dissent before we issue our opinion, but that will also be impossible, close quote. So he's literally sharing their internal messages, putting their internal messages in his dissenting opinion. Folks, this got personal. This got personal. Absolutely. Yet you heard it right. To summarize, in case the reader doesn't get the point, Judge Brown was announcing that he would issue an opinion 3 days later, an opinion that I hadn't even seen and might not be furnished before its issuance. That is unthinkable, but it occurred, and not accidentally. A day later, at 10:30 p.m., Thursday, November 13th, Judge Brown sent a message stating, quote, I've attached a complete draft of all our memorandum opinion in order granting the injunction. We still have revisions to make, but we wanted to get this to you and assist in the preparation of your dissent, close quote. The draft was 168 pages, 655 footnotes, and departed noticeably from the outline I had received. Again, this was the very first actual opinion draft that I had been allowed to see 5 calendar days before the actual opinion was sprung. So he's saying he just dropped 168 pages with 655 footnotes on my desk 5 days before they were going to issue the opinion, the ruling. So he's saying I did not have time to go through all of this and properly note my dissent. Okay? So for that, he says the judge was misbehaving. He said that it was a pernicious misbehavior on the part of the judge. And he goes through what was actually happening right then. He said, I was out of town on Thursday and Friday, November 13th and 14th. to attend the funeral of, coincidentally, a district judge of the Western District of Texas, having driven all day Thursday. Now, let me say this, all right, since he said he'll leave it up to the reader to draw our own conclusion. Well, first of all, condolences to the judge, the district judge there from the Western District of Texas. All right. I don't want anything I say going forward or up to this point to seem insensitive to this judge's death and to his grieving colleague. But the fact that he had to attend a funeral for 2 days doesn't mean that that was pernicious misbehavior on the part of Judge Brown. I mean, yeah, he had to go to his friend's funeral to show respects and so forth. I get that. But that doesn't mean that there was misbehavior on the part of Judge Brown. So Judge Smith is trying to say here, I couldn't, you gave me 5 days, 2 or 3 of those days, I would be out of town attending the funeral. Well, was it possible to show respects to your esteemed colleague without taking 3 days so that you could give your attention to this? I don't know. And once again, I'm not trying to sound insensitive here. Of course you want to be at your good friend's funeral. But was there a different way that he could have handled this? Anyway, I drove back home Friday, arriving after midnight so that my staff and I could spend all day Saturday and Sunday working on the dissent. Early Sunday morning, November 16th, Judge Brown sent a message stating, quote, I've attached a newly revised draft of our majority opinion. We're still making revisions, but this is pretty close to the final version. We are now intending/hoping to issue it on Tuesday, November 18th. That second draft was 161 pages and contains some substantial revisions from the first November 13th draft. So he's saying as we're going through the 168-page draft, the first draft, here we'll dump now with a 161-page draft that is substantially or has substantial revisions from the first. And my dissent is now due in several days. If that was Sunday, then Sunday, Monday, Tuesday. So he had 2.5 days to, complete his dissent. So I guess it was tight. And, apparently I don't know how that vote went when they first conferred and he voted in denial and the other 2 judges said, we're going to, where he disagreed with the 2 judges who said, we're going to deny this, this new map. It sounds like that might have been kind of ruckus a little bit. It sounds like they had a tense conversation and communication potentially broke down at that point. I don't know. And where he says that he didn't hear anything from the other judges, then the question becomes, with all due respect, why didn't he reach out to those other 2 judges? Right? Knowing that he's going to write a dissent, why didn't he reach out? Why was it incumbent upon those 2 judges to reach out to him? I don't know. Just raising questions. He invited commentary. All right, so I replied that I had been out of town, was writing the dissent all weekend, and would be on the road all of the next day, Monday, to attend graveside services for the deceased federal judge. I don't know. So this is 3 days. 3 days when you know you got 5. I don't know. I mean, it's a tough situation where you got to choose between writing a dissent in a very important case and attending the graveside service of a friend. I get that. I understand that. So it sounds like this was just a mess from the beginning. And he's laying it all bare now. I'm just saying, when you look at the facts as he lays them out, you can see this from both ways, right? I know many times as I've practiced law, I got a deadline that I need to do, that I need to make sure I don't miss. But at the same time, something personal and huge is happening with the family. And quite often, if I can't get that thing continued, if I can't get the judge or opposing counsel to agree to change the date, I got to go with the date. I got to just not be at the wedding, or not be at the funeral, or not be at this and not be at that, so that I can meet this deadline on behalf of my client who's expecting me, to take care of his or her business. So tough situation, but I've been there. And anyway, I replied that I'd been out of town, was writing the dissent all weekend, and would be on the road all the next day, Monday, to attend graveside services for the deceased federal judge. I said Judge Brown had no business issuing an opinion as soon as Tuesday. At 11:27 a.m. Tuesday, November 18th, Judge Brown wrote the following, quote, "I've attached the final version. We will intend to issue it today. I'm sorry that we can't wait on your dissent. Purcell compels us to get the ruling out as soon as we possibly can. It turns out that's today," close quote. That third version, 160 pages, was issued a few minutes later with a small number of additional changes, and was ordered and signed on Galveston Island this 18th day of November 2025. All right, so the opinion went out. Didn't have the judge's dissent attached to it, which was unusual, and it stood out, but I didn't know all this was going on. This outrage speaks for itself. Any pretense of judicial restraint, good faith, or trust by these two judges is gone. So now he's literally engaging in ad hominem attacks here. He's just going in personally. All right. In other words, they show no judicial restraint. They show no good faith. And so any pretense about either is gone. If these judges were so sure of their result, they would not have been so unfairly eager to issue the opinion, sans my dissent, or they could have waited for the dissent in order to join issue with it. What indeed are they afraid of? Judges on multi-judge courts understand how important is the deliberative process to fair and accurate judicial decision-making. As I say later in this dissent, judges are paid to disagree as well as to find common ground. Judges in the majority don't get to tell a dissenting judge or judges they can't participate. If the two judges on this panel get away with what they've done, it sets a horrendous precedent that might makes right. In the end, justifies the means. He is literally going in. And again, he is sending a very strong message to SCOTUS that this was not fair what happened. Really. This was not fair. He's saying this was not fair. The majority might even say, we don't need to wait for your dissent and wouldn't read it if we did, close quote. Here, that sort of happened. The entry on the district court docket brings up only Judge Brown's opinion. The reader has no access to this dissent without opening a separate non-consecutive docket entry. So this majority has won in terms of diminishing the impact of the dissent and the public's access to it. In the interest of justice, one can hope it is only a Pyrrhic victory, which basically means a victory that is so out of the ordinary, right? That is really not even a victory. So once again, he's really going in on Judge Brown. When I was newer on the bench, a friend asked me, quote, Now that you've been a judge for a few years, do you have any particular advice? Close quote. I replied, always sit with your back to the wall. So he is really making this personal and showing it for the world to see, but especially SCOTUS. So after laying out that preliminary statement, now he gets into the dissent. The main winners from Judge Brown's opinion are George Soros and Gavin Newsom. The obvious losers are the people of Texas and the rule of law. I dissent. This is just political. George Soros and Gavin Newsom? What? And I am one of the people of Texas. I definitely don't think that we lost from this opinion. And I believe that the rule of law was actually upheld from Judge Brown's opinion. And my feeling has nothing to do with George Soros. And Gavin Newsom absolutely got Proposition 50 passed, but it was in response to Trump in Texas. Gavin Newsom, the Democrats, did not throw the first shot here. President Trump is the one who urged and, suggested this to the state of Texas. This really, really, really gets very personal. It's over 100 pages. We're obviously not going to go through it, but I want to read some more here because the judge is angry. Judge Smith here, Jerry Smith, he is angry, right? But I think he's also wrong. In the interest of time, this dissent is admittedly disjointed. Usually in dissenting from an opinion of this length, I would spend more days refining and reorganizing the dissent for purposes of impact and readability. But that approach is not reasonably possible here because these two judges have not allowed it. The resulting dissent is far from a literary masterpiece. If, however, there were a Nobel Prize for fiction, Judge Brown's opinion would be a prime candidate. I mean, wow. Wow. So now the opinion that Judge Brown issued, this judge calls it fiction. False. Not based on evidence. In other words, he is begging for SCOTUS to overturn this. Begging. He is telling SCOTUS to do everything you have within your power to not allow this Pyrrhic victory to succeed. Otherwise, the great people of Texas and the rule of law will suffer because, respectfully, Donald Trump doesn't get his way. So he's essentially saying that Judge Brown is showing extreme judicial activism, which means he's saying the judge is acting more like a legislator than a judge, because judges are supposed to just call balls and strikes. They're not supposed to try to legislate from the bench. And he goes on to make that point. Judge Brown could have saved himself and the readers a lot of time and effort by merely stating the following. I just don't like what the legislature did here. It was unnecessary, and it seems unfair to disadvantaged voters. I need to step in and make sure wiser heads prevail over the nakedly partisan and racially questionable actions of these zealous lawmakers, just as I did to the lawmakers in Galveston County in Petaway. I'm using my considerable clout as a federal district judge to put a stop to bad policy judgments. After all, I get paid to do what I think is right. In 37 years as a federal judge, I've served on hundreds of 3-judge panels. This is the most blatant exercise of judicial activism that I have ever witnessed. There's the old joke. What's the difference between God and a federal district judge? Answer, God doesn't think he's a federal judge. Or a different version of that joke, an angel rushes to the head of the heavenly host and says, we have a problem. God has delusions of grandeur. The head angel calmly replies, what makes you say that? The first angel whispers, he's wearing his robe and keeps imagining he's a federal judge. Only this time it isn't funny. In other words, he's saying that Judge Brown is acting like he's God. And he has the power to undo what the Texas legislature did and drawn a new map that affects minorities only. This is like reading a good book. I dissent. This is like reading a good book. I'm going to read this last little bit here. I can't put the book down. Judge Brown is no stranger to a spirited attack on the legislature's body's exercise of its duly elected power to redistrict. Before being roundly reversed by the Fifth Circuit sitting en banc, Judge Brown, imagining himself to be a legislator, wrote the following. Now, what we're about to read, I love. It just shows that this judge, Judge Brown, is fair. It shows that he's fair, that he takes seriously how racial discrimination can deny black people, black and brown people, their right to vote. That's all this says. But to Judge Smith, this is offensive. The 2021 redistricting process occurred within a climate of ongoing discrimination affecting Black and Latino voting participation. Black and Latino residents of Galveston County bear the effects of discrimination. He's saying what so many judges probably would not have said and would not have been moved by. Anglo commissioners are evidently not actively engaged in specific outreach to Galveston County's minority residents. Black residents in Galveston County are more likely to be arrested, and Black and Latino residents comprise a disproportionate percentage of jail and prison inmates. This just sounds like a good judge, like a fair judge, appointed by Trump. But this one seems to be fair. The plaintiffs do not need to initially show that partisan affiliation does not cause divergent voting patterns. Practices exist in Galveston County, including voter purges and racially disparate access to polling places. He's pointing out all of the voter suppression that goes on in Galveston County in his opinion. That's not being a judicial activist. That is being a fair judge. It is stunning how completely the county extinguished the Black and Latino community's voice on its commissioner's court during 2021 redistricting. This is not a typical redistricting case. What happened here was stark and jarring. The Commissioner Court transformed Precinct 3 from the precinct with the highest percentage of Black and Latino residents to that with the lowest percentage. The circumstances and effect of the enacted plan were mean-spirited, egregious, given that there was absolutely no reason to make major changes to Precinct 3. This just sounds like a man with a conscience. Just sounds like Judge Jeffrey Brown is a conservative with the conscience. That's all. What he said, him making those observations in that opinion, the Pettaway opinion, thank God for him. He just has a conscience. But boy, you cannot have no conscience in MAGA. You can't show any weakness. No egalitarianism. No empathy. No truth telling. Can't do that. You'll get attacked for that. And attacked is what Judge Jeffrey Brown is receiving. So this is only the page 6 of his opinion. There are 100 more pages. Obviously, I can't get into all of it, but he basically just disagrees, and the ad hominem attacks just continue throughout. And again, just probably the craziest dissenting opinion that I've ever read. All right. So I'm Reverend and Civil Rights Attorney Augustus Corbett. Thank you for watching this video. And as always, stay woke.